Good afternoon. I'm here to discuss all about different kinds of obligations, Section 1, pure and conditional obligations. According to Article 1179, every obligation whose performance does not depend upon a future or uncertain event or upon a past event unknown to the parties is demandable at once. Every obligation which contain a resolutory condition should also be demandable without a prejudice to the effects of the happening of the event. So, Article 1179 in the first paragraph is speak of pure obligation. In the pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment and it's therefore immediately demandable. Simple promissory note to pay certain amount within a certain period is an example of a pure obligation. So for example, I promise to pay Mr. Divino the amount of 10,000 pesos on January 30, 2019. So I have an obligation to pay a certain amount within a certain period. In a conditional obligation is one the fulfillment of which is subject to a certain condition which may be an event which may or not happen. It could be suspensive or resolutory. So for example is I will give you my car if you pass the CPR examination. The condition here is suspensive. Meaning of condition. Condition is a future and uncertain event upon the happening of which the effectivity or extinguishment of an obligation or rights subject to its event. So, conditional obligation is one dependent of an uncertain event. If the obligation may not be enforced until the uncertain event occurs, the condition is suspensive. If the obligation may be immediately enforced but will come when the uncertain event occurs, the condition is resolutory. Two principal kinds of obligation. First is suspensive condition. If the suspensive condition is never fulfilled, the suspended rights and obligation never come into existence and it will be if the agreement was never concluded. So in other words, suspensive for the short term, the fulfillment of the event will give rise to an obligation. Second is resolutory condition or condition subsequent, one the fulfillment of which will extinguish an obligation or right already existing. For example, Arvin binds himself to lend his only car to Ayan until latter passes the CPA board. The obligation to lend is immediately demandable. Ayan rights over the car is extinguished upon his passing the CPA board. Ayan now obliged return the car. An obligation is demandable at once versus when it is pure according to Article 1179 Part 1 on Civil Code. Second is when it is subject to an resolutory condition, or 3 when it is subject to a resolutory period according to Article 1193 Part 2 on Civil Code. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation should be deemed to be one with a period subject to the provision of Article 1197. So the moment of the payment is dependent upon the will of the debtor. Duration of period depends upon the will of debtor. A period is a future and certain event upon the arrival of which the obligation subject to it either arises or it's extinguished. So, when the debtor promises to pay when his means permit him to do so, the obligation should be deemed to be one with a period. If the debtor and the creditor cannot agree as to the specific time, the court should fix the same on the application of either party. Second is other cases as when the debtor binds himself to pay. So there's one example below. Article 1181, in conditional obligation, the acquisition of rights as well as the extinguishment or loss of those already acquired should depend upon the happening of the event which constitute the condition. And for this article 1181, a conditional obligation is an obligation wherein its fulfillment or termination depends on certain condition. The conditions can be an uncertain future event or a past event that is unknown to both the agreeing parties.
Hello, I am Kyla. I am discussing the effects of happening in the condition and some types of a condition.
First, we have acquisition of rights.
Means if the suspensive conditional obligation is impossible to fulfill, then the law will consider that condition to be never existed, and we have loss of rights already acquired. It is subject to resolutory condition. For example, I will give you allowance until you graduate. The right will lose after you graduate. Always remember that possessive condition depends only one of the parties, where suspensive condition depends upon the will of the debtor. First, we have conditional obligation void. It's on the part of the debtor in a possessive as well as in suspensive condition. Conditional obligation is void because it states under the Article 1182 when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. For example, next, only the condition is void. For example, in this statement, only the condition is void but not the pre-existing obligation of D to pay C. D promised to pay C, that is the obligation. D promised to pay C after D sells his car, and that is the condition. There's a pre-existing obligation so that the condition is not valid. Where suspensive condition depends upon the will of the creditor, the obligation is valid. For example, X obliged himself to give Y a golden bag if Y will go to the mall. It is a possessive on the part of the Y as well as suspensive condition because there will only be an obligation when the condition occurs, or Y will go to the mall. Where resolutory condition depends upon the will of the debtor, the obligation is also valid. Casual condition. It depends upon the chance or will of the third person. For example, D is to give C 10,000 if X goes to Baguio. If X goes to Baguio, then D will give to 10,000 to C. Mixed condition. It depends partly upon chance and partly upon the will of a third person. D is to give C 10,000 if C will marry X. D is the debtor, C is the creditor, and X is a third person. As you can see, the condition depends on the creditor and the third person, and the obligation here is valid.
I'm Kate Joshua B. Gallardo. When Article 1183 applies, Article 1183 refers to suspensive conditions. It applies only to cases where the impossibility already existed at the time the obligation was constituted. There are two kinds of impossible conditions: the physical impossible conditions and the legally impossible conditions. Physically impossible conditions, when they, in the nature of things, cannot exist or cannot be done. It is naturally impossible not to happen. For example, I will give you 10,000 if it will not rain for 1 year in the Philippines. The given example is clearly impossible not to happen. The second one is the legally impossible condition. Legally impossible condition is not really possible. Means, pwede siyang gawin or kayang gawin ng isang tao pero hindi siya pwedeng gawin because it is against according to the law, morals, good customs, public order, or public policy. Now, let us proceed the effects of impossible conditions. The first one is conditional obligation void. Is impossible conditions annul the obligation which depends upon them. The reason behind the law is that the obligor knows his obligation cannot be fulfilled. He has no intention to comply with his obligation. For example, Maria will give Juan 10,000 if Juan will kill Pedro. Here, both the obligation and the condition is void. The second one is conditional obligation valid. According to Article 1183, not to do an impossible thing, both obligation and condition is valid. Just disregard the condition because the condition is always fulfilled when it is not to do an impossible thing, so that it is the same as if there were no condition. The third one is only the affected obligation void. If the obligation is divisible, the part thereof not affected by the impossible condition shall be valid. For example, I will give you 10,000 if you sell my land, and a car if you kill Pedro. The obligation to give 10,000 is valid, but the obligation to give a car is void because it is dependent upon an impossible condition. Only the condition void if the obligation is a pre-existing obligation and thereof does not depend upon the fulfillment of the condition which is impossible for its existence. Only the condition is void. According to Article 1184, the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires or if it has become indubitable that the event will not take place. This article is about the positive condition that some event will happen at a determinate time. Positive condition. The above article refers to a positive or suspensive condition, the happening of an event at a determinate time. A positive condition refers to an event that is to take place in order for a condition to be met at a determinate time. The obligation extinguish. First, as soon as the time expires without the event taking place, or as soon as it has become indubitable that the event will not take place although the time specified has not yet expired. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in the mind the nature of the obligation. Negative condition. The above provision speaks of a negative condition that an event will not happen at a determinate time. The obligation shall become effective and binding. First, from the moment the time indicated has elapsed without the event taking place, or from the moment it has become evident that the event cannot occur, although the time indicated has not yet elapsed. Article 1186. The condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. Constructive fulfillment of suspensive condition. First, the condition is suspensive. Second, the obligor actually prevents the fulfillment of the condition. And third, he acts voluntarily. Constructive fulfillment of resolutory condition. Article 1186 applies also to an obligation subject to a resolutory condition with respect to the debtor who is bound to return what he has received upon the fulfillment of the condition. Article 1187. This article is applicable only to suspensive conditions where there was fulfillment. The effects of conditional obligation to give shall retroact to the date of the constitution of the obligation of the suspensive condition had been fulfilled.
Retroactive effects of fulfillment of suspensive condition. In obligations to give, it's subject to a suspensive condition that becomes demandable only upon the fulfillment of the condition. But once the condition is fulfilled, the effects of it shall retroact to the day when the obligation was constituted. It is because the condition is only an accidental element of a contract. In obligations to do or not to do, no fixed rule has been provided for the application of the principle of retroactivity in relation to obligations to do or not to do. But it doesn't mean that in these obligations the principle of retroactivity is not applicable. Retroactive effects as to fruits and interest in obligations to give. In reciprocal obligations, there is no retroactivity in this case because the parties involved in the condition of release that are deemed to have mutually compensated. This is necessary for purposes of convenience, so that they do not have to render mutual accounting of what they have received. In unilateral obligations, the debtor receives nothing from the creditor. In this case, fruit and interest belong to the debtor unless it appears that the intention of the creditor was different from the indebted person. According to the Article 1188, the creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right, while the debtor may recover what during the same time he has paid by mistake in case of suspensive condition. Rights pending fulfillment of suspensive condition. Rights of creditor. The owner of property is entitled to a certain number of rights, which he may use to prevent the alienation or concealment of the property of the debtor. He may also have his right annotated in the registry of property by an official body such as the High Court. This rule applies by the analogy to obligations subject to a resolutory condition. Rights of debtor. The debtor is entitled to recover what he has paid by mistake, whether or not he is able to fulfill the condition set out in the terms of the loan agreement. He may or may not be able to do so, and it is not certain that an obligation will arise as a result. This is a case of solutio indebiti, which is based on the principle that no one shall enrich himself at the expense of another. According to Article 1189, there are rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. First, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. Second, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes or goes out of commerce, or disappears in such a way that its existence is unknown or cannot be recovered. Third, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Fourth, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. Fifth, if the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. The last, if it is improved at the expense of the debtor, he shall have no other right than the granted to the usufructuary. There are 5 requisites for application of Article 1189. The obligation is a real obligation. The object is a specific or determinate thing. The obligation is subject to a suspensive condition. The condition is fulfilled. And the last is, there is loss, deterioration, or improvement of the thing during the pendency of the happening on one condition.
My name is Marquez A. Pauline. I'm going to discuss about the rules in case of loss, etc. of thing during pendency of suspensive conditions. First, loss of things without debtor's fault. Everyone can ask where you were when the things was gone, but when you prove that it's not your fault and you only since it's gone, then you have no obligation to return or pay for it. Second is loss of things through debtor's fault. For me, in case like this, when something is nothing and it is the debtor's fault, it is to prove his obligation to replace it or not. So it is to pay. Because he is at fault when something is nothing, he will be obligated to fix it. Third, deterioration of things without debtor's fault. In this case, he will inevitably be talked to or asked about the deterioration thing if he is not at fault. If he can prove that he is not at fault, he has no obligation to damage. For deterioration of the things through debtor's fault. When the debtor is to blame for the damage to something, and it is to prove whether he will have an obligation to pay for his damage, he will pay it or replace it with a new one because he did not take care of what he did. He damaged the property of another. Everything that is broken has to replace, especially if the owner of the broken item replace it. Fifth, improvement of things by nature or by time. There is really a reason for improving something in nature and time because it is something that we use because of what is happening around us. Often use it and we have our own time for improving things. This is because a person. And 6, improvement of things at expenses of debtor. This is because a person learning something he is already doing and changes. It is himself that he learned the right thing to do and makes the right decision about his action and methods. We must think carefully about our action. Art 1990, when the condition have further proposed the extinguishment of the obligation to give the parties upon the fulfillment of said condition shall return to each other what they have received. In the case of loss, deterioration of improvement of the things, the provision which with respect to the debtor and laid down in the preceding article shall be applied to the party who is bound to return. As for obligation to do and not to do, the provision of the second paragraph of Article 1187 shall be observed as regards the effects of the extinguishment of the obligation. Effects of fulfillment of resolutory condition. First, in obligation to give, when the resolutory condition in an obligation to give is fulfilled, the obligation is extinguished and the parties are obligated to return to each other what they have received under the obligation. Effects of fulfillment of resolutory condition. In obligation to do or not to do in same obligation, the courts shall determine the retroactive effect of the fulfillment of the resolutory condition as in the case where rather the condition is suspensive. Applicability of Article 1189 to 40 with obligation to return. The happening of resolutory condition has the same effects on the creditor as a suspensive condition has on the debtor an obligation to arises. The fulfillment of the resolutory condition converts the creditor into debtor and the debtor into creditor.
Hi, I'm Mark Lemuel B. Sancha. I will be discussing the kind of obligation according to the person obliged and where parties guilty of breach. Kind of obligation according to person obliged. Unilateral. Kind of obligation that there is only one person or party who is obliged to fulfill the prestation or the obligation to give, to do or not to do. Bilateral. When the two parties have mutual bond or tie that they need to comply, and it makes them to be the creditors and debtor of each other. Reciprocal obligation arise from the same cause, and it happen that each party are both creditor and debtor. They are obliged to perform or fulfill the obligation simultaneously. Non-reciprocal obligation. This is the opposite of the reciprocal obligation. In non-reciprocal, there are no imposed simultaneous performance. Choice of remedy by injured party. In case of one of the parties does not comply to or do not fulfill the obligation, they have the right to choose between the two remedies. Number 1. Action for specific performance of the obligation with damages. The demand for the fulfillment of the obligation with the specific thing or performance with damages. And number 2. Action for rescission of the obligation also with damages. The act of demand for cancellation or revocation of contract also with damage. Effect of rescission. It required the both parties bring back to their original state from where the obligation started. And the rescission creates an obligation to give back or return the thing that involved in the contract. Court may grant guilty party term for performance. The court shall decree the rescission claim unless there should be just cause for granting the party in default a term for the performance of his obligation. Obviously, this exemption applies only where the guilty party is willing to comply with this obligation but needs time to do so and not where he refuses to perform. Remedies are alternative. The one who are injured or aggrieved have the privilege to choose only one among the two remedies, and it because the remedies are alternative only. Limitation on the right to demand rescission. Number 1. Resort to the courts. It is a juridical rescission where the injured party has to resort to courts to be able to assert the right juridically. Number 2. Power of court to fix period. The power of the court to give a period in which a person in default may perform or fulfill the said obligation. Number 3. right of third persons. In this case, rescission are not available as a remedy. It is more probably an obligation of responsible person to comply for the damages. Number 4. Substantial violation. In order to have rescission as a remedy, the reason must be a substantial violation or fundamental in order to defeat the object of the parties in making the agreement. Number 5. Waiver of right. The situation where the right to rescind may be waived and there is a thing involved as a collateral for the implied balance. Rescission of contract without previous judicial decree. Number 1. Where automatic rescission expressly stipulated. An agreement where the parties discuss that when violation happen would cause a cancellation and it is without judicial intervention. Number 2. Where a contract still executory. When one of the parties have the will to perform or comply and other is not, the willing party can have the declaration to rescind the contract without previous judicial decree decision. Article 1192. In case both parties have committed a breach of obligation, the liability of the first infractor shall be equitable tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished and each shall bear with his own damage. Were both parties guilty of breach. First infractor none. If one of them violated the obligation subsequently and the other also happened to violate his part on the agreement, the first infractor liabilities will be reduced. First infractor cannot be determined. In this situation where both parties violated the obligation and there is no one who cannot determine the first infractor, the court will not provide a remedy and both parties will bear with his own damages.